Thank you, Counsel. We're here this morning on the motion to dismiss, transfer, or hold in abeyance brought by the government. I've had an opportunity to read the motion, the response, the reply, and the appropriate attachments. I've also spent time reviewing the orders that have come from the various district courts who have similar cases, and this morning I had a lengthy phone call with Judge Sabra in the Southern District of California, where he brought me up to speed on the status of the discovery and planning that is going on in the Miss L case. So with that backdrop, I believe I'm ready to hear you argue this morning.
Thank you, Your Honor. May it please the Court, I'm Scott Stewart on behalf of the defendants. This case should be dismissed out of comity or transferred to the Ms. L court. I think the key issue here, Your Honor, the key reason that the court should dismiss this case or transfer this case to Judge Sabra is that the two cases are substantially similar. The states in this case, the 17 states in the District of Columbia, are bringing claims that are derivative of the parents and children who have been affected by the separation of their families and who are subject to the continuing reunification efforts by the various agencies of the United States. So we have, in essence, the same real parties and interests in the Ms. L proceeding yourself. As you know from talking to Judge Sabra and seeing the various orders now, Your Honor, there are now 4 transferred cases that brings before Judge Sabra both the interests of the parents, Ms. L itself, and of the children. There's a putative class action in the MMM case, which Judge Friedman transferred just a few days ago, and there are also one other putative class action along with other lawsuits representing the interests of various children, particularly in the New York region, where many children comparatively are affected. So same overlapping real parties, same issues as Judge Friedman recognized earlier this week, Your Honor. He emphasized that the relief sought in these cases on behalf of the parents and adults are directly related. These are class action claims dealing with reunification rights of family members, both parents and children. There are a lot of issues that are very far along in the Ms. L litigation and related cases. Judge Sabra has been overseeing and superintending that process for quite a while now. Of course, that suit was filed several months ago, and we're now well into about, I believe it's 5 or 6 weeks into implementation of a comprehensive preliminary injunction in that case. Substantial reunification is underway. We're now moving to a new phase of that reunification that addresses a lot of the outstanding issues of reunification of families with children, Your Honor. We're slated to have a conference or a hearing with Judge Sabra in just a few hours that resolves some important issues there. We're making another submission to Judge Sabra tomorrow, and then having our weekly status conference on Friday with him, which is slated, as I am guessing Your Honor knows from speaking with Judge Sabra, is slated to deal with the bulk of the remaining reunification for parents who are outside of the United States or parents who were released into the interior and have not yet been reunified. So that's a very complex, multi-layered, interlocking process. It would be hard, no judge, of course, has had the chance to craft it and oversee it and understand the details and challenges as Judge Sabra has had. He is fully immersed and ready to continue dealing with these issues, and I think it's important that Judge Sabra continue to deal with those issues and the issues related to them, Your Honor, since the paramount interest in this case and other cases are the reunification, and that is achieved promptly and effectively and without any conflicts in different orders, as now several other judges in New York and in D.C. have recognized. I'd also emphasize, Your Honor, that in addition to substantially similar real parties in interest, substantially similar issues, there are substantially similar claims, and so in some cases essentially identical claims. The core claims here, of course, in this case are due process, both substantive and procedural due process, as well as APA claims. Those are, of course, very much the claims in front of Judge Sabra. There is this additional claim about access to the asylum process at ports of entry that is a bit different from the Ms. L case. But at the least, that's certainly no reason to not to transfer the case, or at least all but that claim, to Judge Sabraw, who can continue his oversight and implementation of these important reunification issues that he's been dealing with for some time now. So again, substantially the same, or in many cases the same merits issues, Your Honor, the same real parties and interests, the same core issues involved, a significant and really extraordinary devotion of resources and effort to all of those issues and reunifications before Judge Sabraw. Judge Sabraw has recognized those efforts at many times in court, but he continues to push to bring this case to a swift resolution. So although this is the case is at the preliminary injunction stage, in some ways that doesn't fully show how far along the case is. It's, substantial reunifications have occurred in the wake of the Judge Sabraw's first 30-day deadline. He continues to closely move things along and keep things on a very, very brisk pace. A few other points, Your Honor, and then I'd be happy to, of course, entertain, hopefully address any questions or save any time for rebuttal. The piece I'd also like to emphasize is just, and this is something that I think Judge Friedman did well to kind of hit in his recent opinion in the MMM case, where he transferred multiple claims in a putative class action to Judge Sabraw. We have the instance here of a class-wide, nationwide injunction that has a lot of moving parts, interlocking pieces to getting the various directives that Judge Sabraw has laid out, getting those right. That's involved a lot of communication, collaboration, hard work between the parties. There are just a lot of meet and confer efforts, just a lot of familiarity that where Judge Sabraw has sort of established a course of dealing between the parties that has led to a lot of effective resolution of things, or moving things along, or sometimes elevating things to the court, as needed. But there's just Judge Sabraw has crafted a situation where all the disparate interests can kind of get together, present issues, work some things out informally, and also just tee up for the court any issues where the court needs to resolve things in the ongoing implementation of the injunction. And I think it's just important to emphasize that proceeding with this case, rather than dismissing it, transferring it, or at the very least holding it, would risk potentially disruption of the case. I think Your Honor recognized the importance of being careful in that regard when Your Honor ordered discovery that was not as broad as the state, I believe, had initially requested, but discovery that had the least likelihood of, I think Your Honor suggested, in affecting continued implementation of the injunction. So we've continued to provide the plaintiffs with information there. My understanding in that regard is that the focus of much of their requests have been location information for the children. I just mentioned 2 points of that, and then would be glad to save remaining time for rebuttal or questions. The first is that most recently we've provided updated information about the locations of the various children who were still in efforts of reuniting, and we've also, that's information that we recently passed on to the class counsel in Ms. L itself. So hopefully in light of that latest production, the plaintiff states here will have a great bulk of the information they want, so there's good progress there. But also that information is hopefully the very best information available to try to complete this reunification process swiftly. And it also, I think, is an example of how Judge Sabraw took careful attention to kind of balance the competing interests. Before Judge Sabraw ordered that production of information last week, Your Honor, he had before him competing requests for how much information should be produced. There was on the table by the class counsel in that case a proposal to produce many Immigration A files. Judge Sabraw considered that. He decided to hold off on that and instead struck the balance where the government would produce this other information that seemed a little bit better calculated to locating and reunifying. So I bring that up as a situation where of why it's been very helpful and very important to have one judge, in this case Judge Sabraw, balancing the various interests and sort of striking the note that keeps the reunification full speed ahead and with the right set of considerations involved. And if there are no questions at this point, Your Honor, I'd be happy to reserve my remaining time for rebuttal.
I have a couple of questions
Yes,
for
Your
you. When we had our discovery conference a week ago, you hit on the topic that the states are interested in finding out where these children are located and whether they're within each state's borders. I take it you know the answer to that question now. And are all 17 states implicated?
I apologize, Your Honor. I don't have that information in front of me right now. It came in at some point yesterday when I was in transit, so I will try to track down that information. But I'm sorry, can't hit the nail on the head with that answer right now, Your Honor.
But at least is the information detailed enough so each state could make its assessment as to whether or not it has children within its borders?
I believe that's right, Your Honor. I mean, there should be address information and that sort of thing of the sort of HHS facility or involved. So,
Judge Friedman held back one of the causes of action in the, I don't know quite how to refer to it, the Triple M case.
yes, Your Honor.
On the basis that that particular cause of action could not have been brought in the Southern District of California. Are there any causes of action in this case that you believe could not be transferred to California?
I believe the answer is no there, Your Honor. I think depending on how and I said I argued in front of Judge Friedman similarly, so I'll tell you sort of what I told him there is that it may be the case that with some claims the government would argue that no district court is able to provide the requested relief or that there might be a reason where it would fail. With the claim that Judge Friedman held back, I think everyone recognized that if the claim could be brought, the only place it could be brought was in the District of D.C. And I don't believe we have a claim like that here. I think those could be brought in other districts, assuming they could make it past other threshold questions. But I don't think there's a Western District of Washington only complaint or claim in there.
Okay. Thank you.
Thank you, Your Honor.
May it please the Court. Good morning.
Good morning.
Laura Clinton from the Washington Attorney General's Office. I'm here today on behalf of the state of Washington, the 16 other plaintiff states, the District of Columbia, our residents, and our communities, all of whom have been affected by the defendant's unconstitutional policies. The defendants have asked you to transfer the case or alternatively dismiss or stay it. I'd like to spend the bulk of my time on transfer. I don't believe the dismissal or indefinite stay requests have much merit. There's no question that venue is proper before this court. The defendants unilaterally transferred dozens of separated parents into this jurisdiction. They placed separated children here and in Seattle and in other areas in our state. The burden is on the defendants to demonstrate a need that justifies transfer, and they have not done so. The existence of the Miss L case is an insufficient basis for transfer, Your Honor. The first-to-file rule, on which the defendants place substantial reliance, does not apply. It requires, as a threshold matter, parties with an identity of interest. There is no party in Ms. L that represents the states or is in privity with the states, and that is sufficient to distinguish every single case that the defendants have cited you to. The cases where the class itself is the same, but the class representatives are different, are distinguishable. The cases in which one party is additional to one of the cases, but the two sides of the V match up, are distinguishable. This court's decision in Music Group Services, on which the defendants place substantial reliance again, is completely distinguishable. There, the successor in interest to a corporation post-merger that held the property rights in dispute in the patent case, this court found that party was sufficiently similar with regard to the two pieces of litigation it was considering. It's an entirely different proposition here. The government's offered you no authority that private parties represent the state's interests for purposes of this rule, and that should be sufficient. But the first-to-file rule also requires an identity of the issues in dispute. All of the Ms. L claims revolve around the individual parental rights that the defendants violated by family separation and the individual remedies for the violation of those rights, reunification. That case addresses the claims of a very narrow class of separated parents. It's been recently expanded by the 4 transfers to address the claims of the children of those class members. The states are differently situated. We have brought broader claims. We have broader interests, and we are addressing the broader impacts of the government's vacillating policies on our southwest border and those impacts in our jurisdictions.
Well, Counsel, let's assume all of that is correct. Why is it that a judge sitting in the southwest border wouldn't be able to adjudicate the state's particular interests just as well as the state of Washington's?
With all due respect to Judge Sabra, we don't doubt that court's ability to adjudicate the claims. The question is whether the defendants have raised a significant showing to justify that transfer. Frankly, we believe that Judge Sabra, who is overseeing the nuts and bolts of this reunification effort that's underway, has ample to oversee in that case, and that transferring our matter to him would serve to just bog down both cases.
And on what basis do you say that? In other words, have you had a discussion with Judge Sabra as to what his resources are?
No, Your Honor. Certainly I have not.
And have you made a comparison with what the state of Washington's resources are here?
No, Your Honor, I have not.
Okay. So what has been happening de facto here with other judges transferring in is not much different than what you see with an MDL case.
That is, in fact, I'm glad Your Honor brought that up. The government here is using the venue statute as if it were an ad hoc MDL proceeding where they get to pick which cases are going to proceed in a consolidated fashion and which will proceed independently. For example, Your Honor has another case related to these policies pending before you in which no motion to transfer was filed, and it's my understanding the government hasn't raised transfer as an issue in that case. I'm referring, of course, to the Padilla matter, that is a putative class action on behalf of separated parents that is pending before this court. And my understanding is there's a motion to certify 2 distinct classes that is pending for decision by this court later this month.
Okay, so let's go back to part of the reason why we have MDL is to handle some of these practical issues. Would you agree with me that the most important issue in all of these cases is to reunify these children and undo this policy?
I would agree with the court that the most urgent need to repair the damage that defendants have caused is to bring those children back to their parents. I don't think that anyone could disagree with that. The states are not interested in overseeing that process. They're not interested in interfering with that process. As we told the court the last time we were here, the reason we didn't file for a preliminary injunction on the subject of reunification is because the same day we filed our complaint, Judge Sabra issued the preliminary injunction, and we didn't want to interfere with that process. We've asked the court to give us limited discovery on certain subjects. We've agreed to accept for the moment the data that's been provided in Ms. L, not because we want to interfere with the Ms. L case, but because that is the most accessible data to the government at this time. And I believe the states have been very respectful of that process, Your Honor.
I understand you recently received some additional information that would help the states sort out whether they actually have children within their borders.
Your Honor, we did receive, counsel's correct, late last night a further submission that I understand was given to the Ms. L plaintiffs. I have not had an opportunity to look at it. My understanding is that it does identify the addresses of some of the separated children in government custody. And there's no doubt that we have separated children in Washington. The Padilla case demonstrates that. The named plaintiff is living here with her son.
And I'm assuming that you also have separated children in California.
I that is probably the case. There are separated children in New York. There are separated children throughout the nation as a result of the government's policies.
Well, if the 17 states have banded together to bring this lawsuit, what about this particular jurisdiction makes any difference? In other words, if it could be brought in California, if it could be brought in New York, these states have banded together in many different types of cases. So, you know, what is wrong with the venue in California, or what is superior about the venue in Washington?
Your Honor, the plaintiffs chose the venue in which they decided to bring suit, and that choice is entitled to deference.
Well, the choice is entitled to deference if there's a reason behind it. What I'm asking you to articulate is why this particular venue is of such significance to you. If you've got another venue where the case could be brought with a judge who is already well-schooled in the issues.
Your Honor, certainly the case could have been brought in California or any other of the plaintiff states. All of them can demonstrate standing, at least we believe so at this time. The plaintiff's choice to bring the suit here, like the Padilla plaintiff's choice to bring their suit here, was a result of factors on the ground in a very fast-moving, fast-paced, vacillating policies. We had women who were detained at SeaTac. We had kids in custody here, and it was the reasonable place to bring suit at the time we filed. We believe it continues to be a good venue for this case. We believe we have full confidence in Your Honor and the companion case that's also venued here. There are cases across the country. There are cases pending in Illinois. There continue to be cases in New York and D.C. There's one in New Mexico that deal with the defendant's policies. The fact that they have moved to transfer only cases that involve the children, mostly putative class actions, that involve the children of the class members and the state's case is curious.
Well, you still haven't answered my question, however, as to why this venue is superior to one in the Southern District of California. In other words, I understand that you filed your lawsuit because of evolving issues, and I certainly understand that with the case brought by Northwest Immigrant Rights Project, you had some named plaintiffs who were visible. But what now makes this a superior venue? Except that you want to be in front of me. And that's flattering, but I'm asking you to articulate, you know, the differences now between having a judge who is involved on a daily basis, if not an hourly basis, with the unification process, if that is the most important thing in this suit.
Your Honor, let me go back then to your earlier question. Certainly I would concede that the most urgent need for these traumatized individuals is to be reunified. But that is not the gravamen of the state's case. We are asking the court for permanent relief on a policy level regarding the defendant's stated intention to inter families together indefinitely, their evasion of the Flores requirements, the family separation policy itself. We have not asked the court to interfere with the reunification efforts, and we will not ask the court to interfere with the reunification efforts. The reason I'm struggling to answer your question about why Washington is superior to California is that's not really the test, I think, for any of the requests that the defendants have made. The request for transfer requires them to demonstrate that there would be some improvement in the litigation if it were transferred. This jurisdiction looks at the Jones factors. None of those factors favor the defendants in this case. again, it's the defendant's burden, and they rely exclusively on the existence of the work that's being done in Miss L.
Well, isn't comedy one of the issues in judicial resources, one of the issues that to be taken into consideration when we look at how many places we litigate?
Certainly, Your Honor. And as for judicial resources, I don't have much visibility into that. I am relying on the many, many statements by the defendants that they've been working night and day on the reunification process, and that those Herculean efforts are taking up the majority of the court's time in Miss L. That is the basis on which I say I believe that a transfer would slow the state's case down as well as the Miss L case.
Well, in order for the states to perfect their case, don't they need discovery? Or at least you ask for discovery be set up on a weekly basis, that you want discovery conferences. And it would appear that some of the things, including what you've just received, may hold the key to how many states still have an interest in this case.
Well, Your Honor, to the extent that the defendants have signaled that they would like to challenge standing of the states in this matter, then I would agree that discovery may be necessary to identify exactly where these displaced children are. We have not, to my knowledge, received complete information on that, with the caveat that I haven't looked at what we received last night. And we do have a pending status conference before Your Honor on the 17th, at which I would expect we would be able to address that more completely. So in terms of whether the states need discovery to perfect their case, I don't know that I necessarily wholeheartedly would agree.
Well,
but yes, we did request discovery.
Okay. Well, one of the challenges that you are likely to face is standing.
Certainly the defendants have indicated that they will bring that motion. They have not.
Well, but I can almost bet on it. In which case, you're going to need the information that currently is being managed by Judge Sabra. My fear is that I enter, if I'm sitting with you every week, entering discovery orders to cover things like your standing issues, covering issues like how the policy was crafted, facing issues of privilege. I run the risk of entering orders that are contrary or duplicative with Judge Sabra's orders.
I do not see that as a substantial risk at this point, Your Honor. The 4 cases that have been transferred, the courts in those cases recognized that the immediate relief those children were seeking had a real risk of conflict with what Judge Sabra was doing. One of them, for example, the children were seeking a different notice period for reunification than the one he had already ordered. These are direct conflicts, or the time period between reunification and potential removal. Those pose direct conflicts. The state's requests for discrete discovery, I am confident that if we cannot work that out with the government, that the court can direct which way they should go.
Okay, what else would you like to have me know?
I would like to add, Your Honor, that 28 U.S.C. 1404A does not require transfer. Again, we're back to the Jones factors. The relevant factors are the choice of forum, which we have discussed, the party's contacts with the forum, which we have also discussed, the claims that are related to the forum, I think we've covered, the ease of proof at cost of litigation. There's been no showing by the defendants that there would be a greater ease of proof in San Diego. The defendants are all resident agencies in D.C. Plaintiffs are throughout the 17 different jurisdictions. There's been no showing that the primary witnesses to the misconduct are in San Diego. In fact, we know they're not. So respectfully, Your Honor, we don't think they've met the Jones factors. And again, we raised the issue of the other cases that are pending all over the country. They didn't even respond to that in the reply. They haven't raised a transfer in the Padilla case, which is based out of the same facts involving some of the same witnesses here. Again, the government's treating this a venue statute like a kind of ad hoc MDL provision, and that's just not what the venue statute was intended to do. We believe the Ms. L court is very busy with a very different task, the nuts and bolts of reunification, and that transfer would only slow down both cases. We respectfully ask that the court deny transfer. I'd like to just briefly discuss the dismissal request. My assumption was that that had been largely abandoned, but I heard counsel reference it earlier, so I'll address it.
I'm not dismissing your case.
Thank you, Your Honor.
You don't need to address that issue.
Fair enough. The stay factors, Your Honor, again, Colorado abstention doesn't apply. That's only state and federal tandem litigation and involves narrow circumstances that just aren't relevant here. So they're asking you to stay this case pending the outcome of Ms. L. And because the defendants have deported hundreds of the class members in Ms. L, there is no way to know when Ms. L will be over and when that reunification process will be concluded. There is no reason that the states would disrupt that work, and there's no evidence that our case would interfere with it. We're asking the court to let us litigate our case here on the merits with regard to the policies that the administration has implemented and has indicated that it will continue to implement. Unless the court has other questions for me, I will rest on a briefing for the others.
Thank you very much.
Thank you, Your Honor.
Any rebuttal, please? Counsel argues that the venue statute is what should control here and the Jones factors. Would you like to analyze those for me and why it is that you think venue is properly transferred?
Sure, Your Honor. I think the question here is really one of sound judicial administration. Your Honor emphasized it when you hit the question of what about this case makes this district a superior venue to the Southern District of California, which is surely a legitimate venue for this case. And the key point is that there's no reason that this venue is superior, and there are strong reasons why the Southern District of California Court is superior, just given how long the lawsuit's gone, the existence of the nationwide class-wide preliminary injunction, the close monitoring and just regular work that the court is doing to make sure that that injunction is implemented swiftly and effectively, the regular contact with parties. I think actually Judge Friedman's order and opinion from last Friday is quite useful in this regard, Your Honor. I think the biggest point that my friends, the states, emphasize is the plaintiff's choice of forum. And what Judge Friedman said to that is, he said, look, the court acknowledges the deference owed to the plaintiff's choice of forum and the inconvenience that could, move from, in that case, transferring somebody from the East Coast all the way across the country. Nevertheless, he said, the court easily concludes the transfer is appropriate given the overlap of issues, where the Ms. L case is, what Judge Sabra is doing. So, although there is some deference owed to a plaintiff's choice of forum, the wise and sound judicial administration and just overall for the judiciary in this case and the interests involved, the parents of the children that the states are claiming to represent here, those are all what cause transfer to be the appropriate answer here, Your Honor. If I could hit just a few other points in rebuttal, in addition to the issue of the superior venue being the Southern District of California. One is, I'd say, there was some suggestion that maybe Judge Sabra might be bogged down with another case. What I can say from that is that, by all signs, Judge Sabra has continued to move everything swiftly. One of the New York cases that was transferred, it was transferred, I believe, a couple Fridays ago, Your Honor, in the afternoon, Pacific Coast time. Within, I believe, a couple hours, Judge Sabra was already holding a conference on that case with the attorneys from New York. It was telephonic. I was in his courtroom at the time, and we were dealing with those issues right away. On last Friday, August 3rd, Judge Friedman transferred the MMM case over to Judge Sabra. By Monday, Judge Sabra had already issued an order dealing with that, setting a hearing on the TRO and therefore today. So he's, been lightning fast in responding to the transferred cases and dealing with the overall issues. And although I obviously wouldn't presume to speak for Judge Sabra's workload, I just give those as data points of how swiftly he's folded in these similar cases involving the interests of the parents and the children into the Ms. L case. One or two other points, Your Honor, regarding these other cases across the country. As we've of course noted, 4 of them have been moved to the Southern District of California. So therefore, those now represent the key merits-related interests that the states are seeking to represent here. As for these other cases, just sort of a few comments about some of the other cases across the country. What's happened in a number of those other cases, first of all, the Padilla case that pending, I believe, before Your Honor, my understanding is that the plaintiffs in that case have said that they're going to hold off on pursuing the Ms. L-related claims, at least for now. So that kind of takes the pressure off of the conflict and other concerns to move quickly. But that's, of course, a fairly recent case, and the government will need to see how to deal with that. A lot of the other cases across the country, Your Honor, and there are not that many of them, but many of them are single plaintiff cases that just tried to kind of seek Ms. L, the kind of Ms. L ordered relief, albeit on a faster timeline. Some of those ended up in orders that just moved quite quickly. They were not the kind of larger scale kind of class action or multi-plaintiff kind of things that presented a bigger risk of conflict. So I believe one mooted out, others, relief was granted swiftly. So that's what I'd mention on those.
You are aware that Padilla has moved for a class?
Yes, Your Honor. Yeah. Yes, Your Honor. And I understand that's still moving. And, I think what the government has tried very hard to do in these cases is just to find an orderly way to deal with overlapping claims. So we will have to make a decision as to what the right approach is there. But I believe that there was this case, the expedited discovery request, expedited schedule request, put some need to kind of it ripened the issue very quickly, and we needed to jump on resolving it. So with those points, Your Honor, I would just emphasize that the superior venue here is before Judge Sabra in the Southern District of California. He has the key interests that the states seek to vindicate on their merits claims. Although the court, of course, it's a discretionary. There's a lot of discretionary features to transfer questions. The factors here are very, very strongly favor transfer in the interest of judicial administration, and the sort of course of dealing, the way these other cases transferred have gone, where they've completely hit the ground running and moved swiftly towards further resolution, confirm that it is appropriate to transfer this case to
Has the government contemplated filing an MDL motion? Does this case fit?
Your Honor, I'm not sure. I'm not certain of the answer of whether it would meet the technical requirements. Right now, with the recent transfers and just the speed at which the implementation of the preliminary injunction has moved, things have been going smoothly, and we've been able to kind of with the help of a number of judges just manage things well, but we may have to just wait and see as to what the appropriate approach is. For now, I think it would be great to just continue on the path of one court really taking ownership of the important issues here.
So your opposing counsel is suspicious that you're picking off particular cases to move transfer for and not others. Is there any other case out there that you're intending to ask for transfer for at this time?
Your Honor, I'm not sure what the Padilla case. We're just going to have to look more closely at how things. As Your Honor noted, one of the alternatives, or as I've noted, one of the alternatives we of course given our briefing is sort of a hold the case pending Ms. L. So, I mean, to the extent that Padilla sort of falls in that bucket, it's helpful. But I mean, just looking at some of the cases that they've, a few of the other cases they've cited. One is, my understanding it's been mooted out. A couple of the Illinois cases, I believe, were single plaintiff cases. We tried to argue comity things. The court ordered relief, and I think that those cases are leading to pretty quick resolution, if not resolution already. So that's been kind of the approach. But we're sort of things have moved extremely quickly. In some of the New York cases, they've been kind of. In New York, they call the sort of immediate kind of docket Part 1, and there's been a lot of Part 1 in those cases where judges have had to respond quickly. So a lot of it has just been reacting in a way that is just most soundly in the interests of administration of the ongoing issues here. So we'd have to sort of wait and evaluate the proper approach in each case. But I think, as I understand, a large number of these, again, I believe that a dozen or so cases have been identified, and I believe most that are not before Judge Sabra are different in kind.
But most of those cases were a single parent, for example, seeking reunification. That has happened, so the case is not moving forward on a larger scale.
I believe that, or there's some other kind of resolution in the works, or something like that. It started to get different when we saw some of these New York cases with bigger complements of people, complements of children, that could have kind of chafed against the preliminary injunction with Judge Sabra's court. It's the multiple, kind of more than a couple plaintiffs thing that have presented the most acute challenges, I think, and we've, to my knowledge, have been pretty swift about trying to move those.
All right. What else would you like to have me know?
I think with that, Your Honor, I've hit the points I wanted to hit in rebuttal, and we'd otherwise rest on the points made in our briefing. Thank you.
Okay. Thank you. It's normally my practice to write orders for the motions that are orally argued in front of me, but because of the nature of the swiftness with which we are moving on these cases, I think it's important that you have my decision now. This case will be transferred to the Southern District of California, to Judge Sabra's court. The primary thrust of all of these cases around the nation is to reunify these families and find solutions for these children that the policies have broken apart. It's their unification that is most important to everyone who's concerned, and anything that serves to slow that down or distract those issues or complicate those issues isn't in the interest of good judicial management. Judge Sabra has been overseeing this unification process. He has had swift deadlines. He has set about an orderly fashion to work through Phase 1 and Phase 2 of these. My conversations with him is that he is willing to accept my decision to transfer the case and will put the necessary resources towards it, and that his job at this particular point in time is to be a manager of the information and materials. There is nothing about the state's interest that isn't parallel with that. The states need the same information. They need to know where these children are. They will need to know where these children are in order to respond to issues of standing. And it's best that they get that information in an orderly fashion, which is what I tried to do last week in our discovery conference. But I think it's best that a single judge manage the discovery. I'm interested in having the government put all of its resources towards swiftly resolving these issues rather than having to respond to multiple courts and multiple orders. I believe that in the M case, Judge Friedman outlined the good reasons, and I would adopt those reasons as my own as well. In this instance, there is not a cause of action that has to be held back because it could only be brought in this jurisdiction. I would urge the parties to think creatively on the issues that are presented to the states, and perhaps there are multiple ways that the issues can be litigated after we move into the theoretical and beyond the practical. But for right now, the practical issue is that these children need to be found, and their parents need to be found, and they need to be united, and this court will not stand in the way of that. So I will issue a brief order. It's my intent to let Judge Sabra know immediately that the case is coming to him, and I suspect that he may have something to say about it this afternoon when you meet with him. Are there any questions about the order or anything further about the rationale that needs to be stated on the record?
No, Your Honor, thank you.
All right. So I know that I still have Padilla, and we'll work through that one when the time comes. Thank you for your arguments.
Please rise. Court is in recess.